traditional custodians of the lands from which senators and witnesses are participating remotely. I pay my respects to their elders past, present and emerging. The committee's proceedings today will follow the program as circulated. These are public proceedings being broadcast live via the web and in Parliament House. I remind witnesses that in giving evidence to the committee, they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence to the committee. The committee prefers evidence to be given in public, but under the Senate's resolutions, witnesses have the right to request to be heard in confidence, described as being in camera. If you are a witness today and intend to request to give evidence in camera, please bring this to the attention of the Secretariat as soon as possible. If a witness objects to answering a question, the witness should state the ground upon which the objection is taken, and the committee will determine whether it will insist on an answer, having regard to the ground which is claimed. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. Such a request may, of course, also be made at any other time. A witness called to answer a question for the first time should state their full name and the capacity in which they appear, and witnesses should speak clearly and into the microphone to assist Hansard to record proceedings. Mobile phones and other electronic devices should be switched off or turned to silent mode. So with the formalities over, I welcome representatives from the Department of Prime Minister and Cabinet, Department of Infrastructure, Transport, Regional Development and Communications, Copyright Agency Limited and IP Australia. Thank you for taking the time to give evidence today. Information about parliamentary privilege has been provided to you and is available from the Secretariat. I remind senators and witnesses that the Senate has resolved that an officer of a department of the Commonwealth or of a state or territory shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution prohibits only questions asking for opinions on matters of policy and does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. The committee has received a submission from the Department of Prime Minister and Cabinet as submission 4. If you wish to make any corrections, please let us know. For the Hansard record, would you each please state your full name and the capacity in which you appear today, and also if you'd like to make a brief opening statement.
Hi, I'm Emma Shadbold. I'm the Director of the Copyright Reform and Policy section in the Department of Infrastructure, Transport, Regional Development and Communications.
Morning, Chair. John Reid, First Assistant Secretary, Government Division, Department of Prime Minister and Cabinet.
Good morning, Senator. I'm Michael Schwager, the Director General of IP Australia.
Good morning.
And I'm Libby Bolsh. I'm the Policy Director at Copyright Agency.
Good morning to you all. On the line, just for your benefit, we have Senator Thorpe in Victoria, Senator Stoker in Queensland, Senator Davey in New South Wales, Senator Dodson in Western Australia, as well as Senator Lyons and also Senator O'Sullivan, who are joining us today for these proceedings. Do you have an opening statement?
No, I don't.
No, Senator.
Okay. Ms Bolch, do you have one?
I do have one if it's helpful, but otherwise we can put those comments in our written submission. I'm not sure what's most useful for the committee this morning.
Oh, look, by all means, feel free to make your statement. That will be fine, and then we'll go to senators.
Thank you very much. So I understand that we've been invited to this hearing today to describe to the committee how two of the statutory licensing schemes in the Copyright Act apply to flags such as the Aboriginal flag. As the committee has heard, flags are regarded as artistic works for the purposes of copyright. So a statutory licence allows certain uses of material that's protected by copyright without the permissions that are usually required, subject to fair compensation to the copyright owners. Copyright Agency manages two statutory licences that cover the use of artistic works, including flags. One statutory licence allows copying and communication for educational purposes by educational institutions, including schools and universities, TAFEs and vocational education bodies. For example, a teacher could make copies of the flag to give students in their class. The other statutory licence allows uses for government purposes and applies to the Commonwealth, states and territories. Copyright Agency is a private not-for-profit company that's known as a copyright management organisation or collecting society. Our members are owners of copyright in text and images and include writers and publishers. Membership is free. We currently have more than 37,000 members, some of whom represent other owners of copyright as their agent. The statutory licence provisions in the Copyright Act for each scheme provide for the appointment of a collecting society to manage the scheme, and that's known as a declaration. So Copyright Agency was declared in 1990 as the collecting society responsible for managing the statutory licence for education for text and images, but then relevant for the Attorney-General. Declaration has remained in place since then. The current Minister is the Minister for Communications, Cyber Safety and the Arts. Copyright Agency was declared in 1998 as the collecting society for managing the statutory licence for governments as it applies to government copies of text and images. And that declaration was by the Copyright Tribunal of Australia and it remains in place. The licence arrangements under each of these statutory licence schemes are what is known as blanket licensing arrangements. For example, we have arrangements with the education departments in each state and peak bodies, schools in non-government sectors that cover copying and sharing of text and images for educational purposes that otherwise require a copyright clearance. Similarly, we have agreements with the Commonwealth and with the states that cover government copies made by departments and agencies. Those agreements also cover internal communication, such as emailing and availability from an internal server, but not to external communication, such as publication on a website that's available to the public. Each agreement provides for an annual fixed price fee to cover all copying and sharing by the relevant sector under the licence. We distribute the copyright fees we collect to owners of copyright whose works have been used or available under the licences. We don't receive comprehensive reporting about every single use under each of the licences because the cost of doing that is currently prohibitive. We do receive data about usage in schools and universities from annual surveys in small samples of schools and university faculties. And we use this information to assist us to distribute the licence fees we receive in all sectors. We also have an annual distribution for artists whose works are available for use under the licences we manage. In addition to the statutory licences, we also manage a range of other licences as agent for our members if they choose to participate in those licences. These include a pay-per-use licence for the use of artistic works, including in publications on merchandise and on clothing. Thank you.
Thank you very much. I'll go to Senator Davey for the first questions.
Thank you. Just got to find my mute button. You'd think I'd be used to it by now. Ms. Balch, without going into any commercial detail, which I understand is in confidence, but is Harold one of the artists that you collect and distribute licence fees for?
He is. We obviously can't disclose how much money is paid to our members without their consent.
No, and I certainly wouldn't want you to. Could you describe some of the other works that you collect licence fees from? Is there any other work akin to the Aboriginal flag that has a sort of a symbolic and community-wide recognition that you also collect licence fees and act on behalf of?
The licences cover the use of any flags that would otherwise require permission. So they also cover the use of the Torres Strait Islander flag that the committee heard about earlier, and the Olympic flag, which is protected by special legislation. I can't think of any other sort of analogous situations, but the licences apply in a neutral way to any work which is an artistic work for the purposes of copyright.
So does that also then apply to other Indigenous artworks that may be reproduced in school textbooks or, used by government, Commonwealth government agencies, reproduce? Is there a licence arrangement and you work on behalf of those licence holders?
Yes, so both of the statutory licences apply to those artworks, and also the other licences where we're appointed as an agent, they also apply to those artworks if the artists have appointed us as their agent to do that.
So in those, that is a way that those artists get due recognition and compensation for the work that they've created.
That's right. And I might just mention there's another scheme that we manage called the Artists Resale Royalty Scheme, whereby 5% of the resale price is paid back to the artist. And that's another scheme that we manage for artists as well.
And we're talking about copyrighted material, not just the Aboriginal flag, but in general, more generically, with copyrighted material. Are there penalties for misusing copyright material, for using copyrighted material without paying the licence fee or a royalty?
There are, so that if permission is required under the copyright legislation and somebody proceeds without that permission, that's referred to as an infringement of copyright, and yes, there's a range of penalties for that.
And how often is it a common occurrence that people are caught up in some sort of a prosecution or a cease and desist manner for breach of copyright?
That's probably beyond my field of expertise. Our business is about licensing the legitimate uses of copyright material to a range of different people.
Thank you. I just also have a question for the Department of Communications. At our hearing on Monday, we heard commentary that while the Commonwealth could potentially enter an agreement with Mr. Thomas about the commercial copyright, he would retain the moral copyright. Could you please explain the difference for us between copyright and the moral rights?
Yes, happy to do that. Can I firstly just acknowledge the traditional custodians of this land, the Ngunnawal people? I would also like to pay respect to the elders past, present and emerging, and extend that respect to other Aboriginal and Torres Strait Islander people present. So the difference basically in copyright, there's two types of rights. There's the economic rights, and I understand that the academics and the legal experts you had on Monday went through that very clearly, and I don't have anything to add to that except to say that basically the difference between the two is, so there's the economic rights, which are the exclusive rights, which are those to reproduce the flag, to then communicate the flag, that includes electronically and broadcasting it, or to publish it. So they're all economic rights in which the copyright owner or the original artist can enter into arrangements with others to use that material, and they're often licenses either through exclusive licenses, through full assignment of the copyright to another, or through non-exclusive licenses with different parties. And through that they can gain either remuneration or they can allow that material to be used under things such as Creative Commons licences, which I think Professor Weatherall referred to. So it can either be a remunerable or non-remunerable action. So they're the exclusive economic rights. Then on the other hand, you have what we call moral rights, and they, unlike the exclusive rights, are non-assignable, because the idea behind these rights is that they give the artist or the original creator the ability to have attribution about their work and integrity in their work. So there's basically three moral rights. The first one is that there's the right of attribution of the author's or artist's work, so that they're appropriately attributed. The second right is that against false attribution, so that the work isn't falsely attributed to another artist or to another copyright owner. And thirdly, it's the right of integrity of authorship. So basically, you can object to treatment of your work, of the artist's work, which they consider has a detrimental effect on their reputation. So often derogatory work, an example might be an artistic work in a public place. If someone's graffitied that or has changed it in a substantial way, they can take action around that. And as I said before, they are non-assignable generally.
So if we were to leave Mr. Thomas just with his moral rights, that gives him due credit for authorship, but effectively no compensation, no recompense, no financial recognition for his artwork and for its ongoing use and recreation.
That's correct, Senator. Often the moral rights have got no economic value.
Okay, that's it from me at the moment. Thank you, Chair.
Thank you, Senator Davey. I'm just checking if Senator Thorpe is on the line. I know you are having some technical difficulties. If Senator Thorpe is still finding her way online, I might go to you, Senator Dodson.
Thank you, Madam Chair. This is indeed a landmine field of activity, isn't it?
Yes.
In the submission that the Prime Minister's Department issued, there's at point 7 of that, at point 6, it says that the federal court declared that Mr. Thomas was the owner of the copyright of the Australian Aboriginal flag, with its use protected under the Copyright Act. Now, the use, is this the diverse set of uses that you've spoken about? I forget who the person was, the last witness spoke about.
I'll answer that. Sorry, it's Mrs. Chadbolt from the Department of Infrastructure. Yes, that's. I understand that's correct. Concurring with my PM&C colleagues, that the understanding is that in being deemed the copyright owner, he therefore has the full range of exclusive rights available to him. Okay,
and if you could answer point 7 for me, particularly on the question of display. However, the permission is not required, no permission is required to fly or display the Australian Aboriginal flag. What's the definition of display?
Senator, it's John Reid, First Assistant Secretary, Government Division at Prime Minister and Cabinet. We obviously are responsible for protocol around displaying flags and how that is done. The Copyright Act and the copyright rights go to reproduction. So the position of Prime Minister and Cabinet is that the copyright rights and obligations don't affect the ability of all Australians to fly the flag.
And what about display? What's that mean?
Well, Senator, I guess there's a difference between, or the difference we're trying to draw out there is the difference between reproducing the flag, which may require appropriate authorisation under the Copyright Act, and the ability to display it once it's been produced.
So if the AFL puts the flag on the oval, that's a question of reproduction, is it?
Senator, when you say puts the flag on the oval, do you mean spray painting on the grass?
Yes, it displays it on the oval.
Senator, I'm not sure if one of my other colleagues might be able to assist, but that'd go to technical questions about whether or not it's a reproduction or not. What we're interested in, and the point we're trying to make with the point 7 in our submission, is, for instance, the actual flag. So if there was an actual flag that had been licensed and produced properly, there'd be no restriction on the display of that flag. I'm not sure that I can assist on whether or not different depictions are, under the Copyright Act, a reproduction.
Can I just ask if there are is there anyone else who is able to answer that particular question of Senator Dodson's, or would you need to take that as a question on notice, Mr. Reid? Because it is quite a critical question in terms of recent events.
If no one else, I'm happy to take it on notice. I'm not sure if Ms. Shadbolt.
We can probably comment on it from the factual basis. Obviously, this is the difficulty with the copyright. It would be a legal issue in terms of whether that reproduction did constitute a reproduction under the Copyright Act. It's probably likely, given that if it's an exact likeness that's been recreated on the ground, that would fall within the realms of reproduction.
And what about the question of display? That it's being displayed through broadcast?
Well, again, Senator, if it's displaying a licensed reproduction of the flag, that would be, from our perspective, legitimate and appropriate. I think the question again comes back to the copyright questions about whether or not the reproduction is legitimate, as in the actual production of the flag itself.
Okay, so again, this is you're probably aware of the issues that are current. Someone's trying to play music. But this is the tension between, or the dilemma we have as a committee. You have a large body of First Nations people and the broader community who have a view that the flag is somehow or other their property, may not be legally their property, but that it belongs to them. Yet the copyright ownership is clearly vested with Mr. Thomas and his rights to do what he wishes. How does the community concept of its ownership through the public use of this flag over a long period of time, how is that accommodated in the law?
Mrs. Shadbolt again. From a purely copyright perspective, unfortunately, and I think it was explained by some of the legal experts on Monday, even where something is in the public domain for a long period, if it's covered by copyright, that does not matter, because copyright lasts for the life of the author plus 70 years, irregardless of whether that material is being actively used or not used.
So is the problem, if I can use that term, or the challenge, embedded in the contractual arrangements between Mr. Thomas and whomever he's given the exclusive licences to display and use his flag?
That's probably that is one of the issues here, because Mr. Thomas has indicated, or did win the federal court case and has got that ownership, and therefore he is able to make those arrangements as he deems appropriate. And as we've heard in the evidence, he's made several arrangements with different companies in terms of those rights, and so that seems to be the issue here.
So if he wished to vary those arrangements, is he at liberty to do so?
We probably can't comment on that because we're not clear of the arrangements he has with both of those parties or the legal status of those. That would be a matter, obviously, around the contract that he's made with those parties and whether he can make different arrangements.
Okay, so if there's no clause in the contract that enables him to vary it, then the contract presumably will stand for its term. Is that right?
That I can't comment legally, but that would probably be the general position, I understand.
Is anyone there who can help me?
Senator, it's John Reid again from Prime Minister and Cabinet. I think that would turn entirely on the, as you say, on the terms of the arrangement, the legal arrangement that Mr Thomas has, and obviously that's not something that we've seen or have any awareness of.
Okay, so in administering the Copyright Act, you don't look to the detail of any contractual arrangements under which it operates.
That's correct. We merely provide policy advice about the appropriate operation of the Copyright Act. We don't provide legal advice or intervene in enforcement actions or actions of individuals.
So in that sense, there'd be very little purpose in coming to you for advice in regard to the dilemmas that we're currently confronted with.
That's probably correct, and we understand that the NIA are undertaking those negotiations and they would seek appropriate advice, including legal advice, as necessary.
And would that be internally, that is from within the Commonwealth framework, or from private practitioners?
I wouldn't be able to comment on the practices of the NIA.
Okay. Thank you, Madam Chair.
Thank you, Senator Dodson. I'll go to Senator Thorpe, who's on the line now.
Thank you, Madam Chair. My question is, has the government already consulted, or will the government consult in future with the Aboriginal community as part of their negotiations?
Senator, it's John Reid from Prime Minister and Cabinet. The National Indigenous Australians Agency, Mr Griggs and Minister Wyatt are responsible for running those negotiations. I understand Mr Griggs gave evidence to the committee on Monday. I don't think anyone here at the table is involved in those negotiations. Certainly Prime Minister and Cabinet isn't. Minister Wyatt is leading on those things.
Are you able to confirm how far and wide the Aboriginal community have been consulted?
I'm happy to refer that question to the National Indigenous Australians Agency.
Yes, please. My other question is, would the government consider having community-controlled Aboriginal organisations participate in the management of the flag?
Again, Senator, I think that's probably a matter for the National Indigenous Australians Agency. I'd be happy to refer that to them.
Okay. Well, given that Aboriginal people also see the flag as a representation of Indigenous sovereignty, does the government also see this as a representation?
Senator, as Mr Griggs said on Monday, the government sees the flag as a symbol of unity, and the government, as a matter of policy, welcomes the right of all Australians to fly it freely with the appropriate dignity and respect.
That's great, but that wasn't the question. The question was, and this is based on information from the Aboriginal community, that the flag also represents the sovereignty of the First People of this country. And community, are watching in right now and have asked, does the government also see that sovereignty is represented in the Aboriginal flag for Aboriginal people in this country?
Senator, I'm not sure I can add much to what Mr. Griggs has said on the question of the representation of the flag.
Okay. And my final question is, what are the goals of these discussions and negotiations for government? Does the government have any interest in owning the Aboriginal flag?
Senator, the goal, the very clear goal of the government in entering into these negotiations is to end the divisiveness that may be emerging and to ensure that the flag is used freely, but that Mr. Thomas's interests, as well as the commercial interests of all the relevant players, are respected, balanced against the broader public interest that has been, I think, well articulated to this committee this week.
So is the government, has the government taken any steps to take ownership of the flag to date?
Senator, the negotiations, as the committee has been informed, have been led by Minister Wyatt and are reasonably sensitive. Prime Minister and Cabinet, and I'm not sure that anyone else at the table is involved in those discussions. I couldn't comment on what has or hasn't been discussed in those negotiations with Mr. Thomas and the other commercial parties.
Okay, thank you. No further questions.
Senator Stoker.
Thank you very much, Madam Chair, and thank you to each of the witnesses who've made time for us today. My questions go to a slightly different matter than much of what we've been talking about as a committee so far. The final of the terms of reference deals with the way in which we can make sure that the Aboriginal flag is given the kind of understanding and prominence that it deserves, and making sure that it is able to endure and be fairly used by the Aboriginal and the broader Australian community. So with that in mind, I'm conscious of the fact that there's a real lack of understanding of the meaning and significance of many of Australia's flags, from the Australian national flag to our Aboriginal and Torres Strait Islander flags and through to many of the other flags. And I'm interested to know what's going on at the Department of Prime Minister and Cabinet end to make sure that Australians who want to fly our significant flags have access to the information they need to understand how to do so respectfully, in a way that fits with the cultural significance of the flag that they're dealing with, and in a way that respects the necessary protocols.
So I can't even bear her voice.
Sorry, say that again?
No, Senator Stoker, it seems like there was interference there, so I'm not sure what that was, but you keep going.
Okay, so I'm interested to know what is going on at the Department of Prime Minister and Cabinet end to make sure that Australians have access to the information they need to be able to fly our flags in a way that is appropriate.
Thank you, Senator. Department of Prime Minister and Cabinet, of course, does quite a bit of work to make sure that we can publicise all of Australia's official flags, including the Australian national flag and the Australian Aboriginal flag. We have the Australian flags booklet, which is available online and also available to ministers and senators and members to publicise through their electorates, which goes through, as you've said, Senator, the way in which the national flag should be flown, orders of precedence and things like that. We also do quite a lot of work around Flag Day in September to ensure that both the community community is informed through our social media platforms, but also to ensure that all parliamentarians are provided with a decent amount of information through Assistant Minister Morton, who within the Prime Minister's portfolio is responsible for national symbols and honours, to make sure that all parliamentarians have access to the information they need for their constituents. And we usually, around the lead up to Flag Day in September, bolster our social media campaigns and also bolster the amount of information flowing through to parliamentarians' offices. And we are keeping under constant review the sorts of information we have on the website and ensuring that the booklets are all up to date.
Thank you. I should give some disclosure to the committee in case there's any suggestion that this needs to be on the record. I am someone who takes an interest in Australia's flags and in particular Australia's national flag. So I'm a member of the Australian National Flag Association, and they've provided a submission to this committee recently that makes a very good point, I think, and that is that if you are an Australian who is either wanting to fly flags at home or who is wanting to fly flags as part of your involvement in an RSL or a school or a community group, it can actually be quite tricky to get your hands on the information that you need to make sure that you're doing that in the appropriate way. What effort is being undertaken to try and make it easier for people to find the information they need? Because my experience of digging through the Department of Prime Minister and Cabinet website, as good as it is that it can take quite a bit of time to get to the right place if you're interested in answering a specific question, for instance, about flag protocol.
Thank you, Senator. The department is always interested in ways we can publicise this material better. We do have the Commonwealth Flag Officers Network, which we use through email and other things out of the department to ensure that we're getting the right messages out and anyone is able to sign up to that network. But we are always interested in ensuring that information is accessible and as freely available to the entire Australian population as it possibly can be.
One of the suggestions that's come from the Australian National Flag Association is that while the information that is provided by government on this subject is high quality and it's accurate, and it points out important things like the fact that there is a difference between the Australian national flag and our important cultural flags and other declared flags, and how to display those in a way that reflects, I guess, their relative ranking and all of those sorts of considerations. But it would be helpful to have something like, flag.gov.au that easily redirects people to the right bit of the Department of Prime Minister and Cabinet's webpage, so that people can have what they need at their fingertips. One of the troubling things that was raised in the submission is that if the efforts that we were making as a government to make sure people could access everything they wanted to know about the different flags that are important in Australia was there, then groups like ANFA wouldn't be receiving so many queries from community groups about how to do this properly. So I offer that as a suggestion, and perhaps you could take that suggestion away with you and consider that as part of your ordinary work. I should probably give you an opportunity to respond to that. Are you prepared to do that?
Thank you, Senator. I'm afraid I haven't seen the ANFA submission to this committee, but presumably it will be made available, and I'm very, very happy to take that on board.
Thank you. One of the other suggestions that they quite helpfully offer is that there is a lot of confusion among members of the community about the significance and the differences between the different types of flags that we have. Very few people, even I think some members of this committee were not clear about the way that the Flags Act deals with the different types of flags, the differences between an Australian national flag and other declared flags that are different but still very significant to Australia, and that need to be treated in a different way. So if you wouldn't mind taking on board that need for better education, both in terms of web access, but also in terms of our school activities. There's lots of education, as far as I can see, about why the Aboriginal flag matters, and that's appropriate, but perhaps not as much education about the history of the different flags, how they became declared, and the relationship between the different flags of this country.
Absolutely, Senator.
Thank you very much. That's all for me, Madam Chair.
Thank you, Senator Stoker. Could I just check on a couple of things, Mr Reid? Can you clarify what the legal effect of a declaration under Section 5 of the Flags Act is?
Senator, the effect of a declaration is that the flag, the declared flag, the proclaimed flag, is regarded as, quote, an official flag of Australia. That allows the Governor-General to make rules about that flag if he or she so wished, and it puts the flag within orders of precedence in relation to flag protocol, which is published by the Department of Prime Minister and Cabinet.
Okay, so can you elaborate how that legal effect might interact with the rights afforded to a copyright holder under the Copyright Act?
Chair, it doesn't in any way. So a proclamation under the Flags Act doesn't affect private rights or interests, including those under the Copyright Act.
Okay, can I just ask, have you been asked to provide advice to government on the Aboriginal flag and specifically advice on Mr Thomas's rights?
Chair, so obviously that matter's being led by Minister Wyatt and the National Indigenous Australians Agency, but yes, we provide regular advice or regular reporting to the Prime Minister, and we have also provided a briefing to, as I say, the Assistant Minister, Minister Morton, who's responsible within the Prime Minister's portfolio for these matters. We've provided briefing to him.
And when was that briefing provided?
Just a moment, Senator. August this year.
Sorry, what was that, Mr Reid?
24th of August this year.
24th.
We briefed Minister Morton in order to make sure that he was informed of the issues around this matter.
On the issues in relation to the flag,
the
and
Aboriginal,
Mr Thomas? Yep.
That's right, yep. And also more broadly in relation to the operation of the Flags Act, so that he had a proper understanding, a good understanding of that.
And are there any documents there that you're able to table to the committee in regards to that briefing?
I don't have any documents with me, Senator. I'd be happy to take that on notice.
Okay, thank you. That would be good. Thank you very much. We request the documents for the committee, and we also have until September the 18th for questions on notice to be responded to, Mr Reid.
No worries.
So you say the 24th of August was when you briefed Mr Morton. Have there been any other briefings, even for the Prime Minister himself, in terms of the flag?
So we maintain a live brief for the Prime Minister on a range of topics, of course, and one of those topics is...
Do you want to just explain what you mean by that?
So it's a real-time briefing system. I say real-time. It's a regular briefing system. One of the subjects of that regular briefing system is the Aboriginal flag and issues around that. So the department, maintains a reasonably regularly updated brief for the Prime Minister on issues around the Aboriginal flag.
So when you say regular, is that daily or once a week? Or?
It's certainly reviewed as and when anything develops.
And what does that entail, that regular briefing or updates around the Aboriginal flag?
Sorry, Chair, in what way?
Well, you say you talk about the Aboriginal flag as a regular briefing. Do you talk about it in where the flag is being flown or what issues have come up about the flag? What is actually the regular briefing?
It's a written briefing, Chair, and it will capture the public commentary around the issues, any media commentary around the issues, just as a background item.
So generally media commentary more than anything, is that it, to keep an update?
It's to ensure the Prime Minister's
conversation is? Yeah.
Sorry, Chair. Yes, it's to ensure the Prime Minister knows where public discussion is at.
So what would the latest commentary be in terms of the flag? I
don't have a copy of the brief in front of me, and I'm not 100% sure when it was most recently updated, Senator.
Would you like to take that on notice?
I can take that on notice.
Thank you. In your submission, you state that PM&C provides flag protocol advice to assist individuals and organisations with respectful and dignified use of the flags. Well, what sort of advice is that?
Chair, it's broadly around how the flag should be flown. Sometimes questions of precedence, often advice around half-masting at appropriate times.
When would you do that? When would you advise for the half-masting of the Aboriginal flag?
No, sorry, Senator, this is in relation to the Australian national flag.
Okay. And do you do the same with the Aboriginal flag?
No, Senator, we don't. The protocols we maintain, but for questions of precedence and the order in which flags should be flown, the protocols that we maintain and the advice we provide is largely centred around the display of the Australian national flag. I can take on notice, Senator, whether we've provided advice in relation to the Australian Aboriginal flag.
I'd be interested to know because obviously we would understand that you have the Australian flag, but what kind of advice would you provide for the Aboriginal flag and for the Torres Strait Islander flag, for that matter, as well?
I'll happily take that on notice, Chair.
Sure. So what advice, if any, does PM&C provide on the issue of the use of the Aboriginal flag on clothing?
Senator, we don't, although I'll take on notice whether I can search the records. As a matter of course, we wouldn't provide advice on the use of the Aboriginal flag on clothing. We would provide advice directing people to Mr. Thomas, and we have his details on our website and in our materials as the copyright holder.
And what about the fact that Aboriginal flags are provided to, along with other flags, provided to senators and members and politicians in state and territory jurisdictions? Is there any added advice provided in relation to flags on clothes to those senators and members or state and territory politicians?
In relation to flags on clothes, Chair, I think not, but
would you like to take that question on notice?
Correct that on the record if I've misled.
Thank you. I'll come back to further questions. I'll go to you, Senator Davey.
Thank you, and I'll take advantage of you opening that line of questioning, Chair. With regard to advice for flags on clothing, do we also, my understanding is the Australian national flag doesn't have a copyright imposed. We have advice on its use, its colours and its size and how it's displayed. But do we give advice to anyone? I think of every Australia Day and the amount of clothing that comes out with the Australian flag in various guises, including thongs and swimwear. Is there any limit on its use in that way, or do we provide any advice in that way for our national flag? Just as a comparator.
Senator, I'll start, and maybe some of my colleagues at the table who administer some of these things may be able to add, but the only three circumstances in which we require approvals or anything formal like that in relation to the Australian national flag are in relation to importing products with the flag, or applying for trademarks, or registering designs. They're the only three instances where any formal process with the government's required.
So essentially, anyone in Australia can reproduce or produce items or objects with our national flag's design on it without paying any licence fee or copyright or royalty. Would that be fair to say?
That's right, Senator. There are guidelines and protocols around how that should be reproduced, ensuring it's accurate. But yes, that's right.
So I also just want to go back to the declaration under the flag, Section 5 of the Flags Act. My understanding, and we heard the other day that we had both the Australian Aboriginal flag and the Torres Strait Islander flag declared at the same time. But the Torres Strait Islander flag was the result of a competition, whereas the Aboriginal flag had an organic growth. Who owns, is there a copyright over the Torres Strait Islander flag, or is there just regulations around the use held by the council?
Senator, my colleague from the Department of Communications might want to add to this, but yes, you're right. The Torres Strait Islander flag was designed by the late Mr. Namok. On his death, rights in the flag passed to the Torres Strait Islands Regional Council, or the Island Coordinating Council as it then was, and so they hold copyright in that flag.
Did he will those rights to them, or were those rights ceded as part of the competition entry condition?
My understanding, Senator, is that he willed them to the council, but I will correct that if I'm wrong.
Thanks. It's just very interesting if we can get a comparison between the two. And does the council, are you aware of whether the council now charges, I understand they've got quite, they've got strong guidelines about the flag's use and reproduction, but are you aware of whether they charge a royalty or a licence fee for reproduction where it is not done by a council authorised body?
The information I have, Senator, is that they don't charge, but I'm not. It's not within my bailiwick, I'm afraid.
Okay, thank you very much. And I just want to go back to Senator Thorpe was asking about consultation, and I understand that you're not in charge of the consultation on the copyright issues, and I also understand the sensitivities around there. So I don't want to go down into the deliberations on the copyright issues specifically, but just as a matter of course, the Department of Prime Minister and Cabinet and the NIAA, what is your presence on the ground in rural, regional and remote communities, and what general generic consultations do you have with Indigenous communities across Australia, and particularly in areas of, remote areas of the Northern Territory and Western Australia and like the APY lands? Do you have a lot of consultation with those groups generically to get feedback to help with our Indigenous policy formation, and also which would provide us a background and an understanding on specific issues such as this?
Senator, I'm aware that the National Indigenous Australians Agency has a strong regional network across Australia. The Department of Prime Minister and Cabinet doesn't. We have our main presence, of course, in Canberra, and on those issues of regional consultation and community consultation, that's all led by Minister Wyatt and the National Indigenous Australians Agency.
Thank you. I think that's all I have at the moment. Thanks, Chair.
Thank you, Senator Davey. Can I go to Senator Thorpe?
Thank you, Madam Chair. Just on the flag protocols and order of flying flags and such, have Aboriginal people been involved in setting that policy on its administration when it comes to our flag?
Sorry, Senator, can I just clarify, involved in consultation on what exactly? I'm sorry.
The order of flying the flag. So there's, well, first, is there a particular order of flying the flags that we see, the national flags, if you like? And is there an order of which they are flown? And if there is, were Aboriginal people involved in the decision-making around where the Aboriginal flag sits in that process?
So, Senator, yes, there is an order of precedence that's set out in the protocols, which are available. I'm more than happy to make the link available to Secretariat so that it can be seen by the committee, and it sets out the Australian national flag, obviously first, and then in order other flags that are prescribed under the Flags Act. I'm not aware that those protocols have been around for some time. I'm not aware of what consultation was had about the breadth of that order of precedence. It's quite broad. It runs all the way down to defence ensigns and things like that, so it's quite a long order of precedence.
This conference is
so maybe it's a question on notice, because if it was decided to put the Aboriginal flag first or second or third, then were Aboriginal people involved in that decision making? I know that it goes back some time, but is there any evidence as to how that decision came about and why is one before the other?
I'll take that on notice, Senator.
Thank you. I have just a couple of more. Can you give the committee more detail on the process that led to the Flags Act declaration for the Aboriginal flag? What process was to consult with and gain consent from Aboriginal people at that time?
Sorry, excuse me. Yes, Senator, the proclamation of the Australian Aboriginal flag, which happened, as the Chair said earlier, at the same time as the proclamation of the Torres Strait Islander flag in 1995, was a direct result of the government's acceptance of the recommendation by the Council on Aboriginal Reconciliation that those flags be proclaimed as official flags under the Flags Act. So it was a response to that report.
Again, can you clarify what consent was given by Aboriginal people around the flag being proclaimed?
Senator, I don't think I have with me detail around how that process worked, but I'd be very happy to take that on notice.
Thank you. And you have a pretty detailed set of information online about the use and display and management of the Australian flag, but not really much information that I could see about the history, the use and cultural significance of the Aboriginal flag. Can you tell me why that is?
Senator, as I said earlier to one of the other committee members, we are always keen to look at ways in which we can better publicise all of the official flags of Australia, including the Australian Aboriginal flag, and we're constantly looking at ways in which we can provide more information. Obviously, as the Commonwealth's not the copyright holder in relation to the Australian Aboriginal flag, there are things we are simply unable to do to ensure that we respect Mr Thomas's rights and those rights of other commercial interests in the space. We have more flexibility and freedom in relation to the Australian national flag, where we don't have those issues. But we're always keen, of course, Senator, to make as much information available as possible.
Okay, thank you. No further questions.
Thank you, Senator Thorpe. Can we go to Senator Dodson?
Thank you, Madam Chair. Again, I'm not sure to whom this goes, but Mr. Reid seems to be doing a very amicable job there. The question I have is, what would the Commonwealth have to do if it wants to respect Mr. Thomas's rights, but also make the flag freely available to First Nations and the public?
This conference
Senator, I'll accept the invitation to have a first go at that. I think, Senator, that goes squarely to the sorts of things that I understand Minister Wyatt is currently engaged in negotiations with Mr. Thomas and others about, and the sorts of negotiations and discussions either from Mr. Thomas's point of view or from Minister Wyatt's point of view. I'm aware that those negotiations are going on. Obviously, we're not part of those negotiations, and that the positions are sensitive and confidential. So I'm not sure that I would be able to go through the sorts of steps the Commonwealth might want to take in that instance.
I'm not necessarily seeking the steps. I'm wanting to know what options. We hear about compulsory acquisition, and we hear in the same breath the respect for his rights and interest. I'm interested as to how you can achieve that.
Is there anything else, please?
I think it's not.
Mr. Reid?
Sorry, Chair. Senator, there's obviously a range of options that would be on the table to try and satisfy all of the competing needs and interests here. I'm aware that those negotiations are exploring the full gamut of options. I am not, as I said, I'm not involved in negotiations. I'm not entirely sure what options might be available to Minister Wyatt at the moment. Obviously, once those negotiations have concluded, we anticipate him reporting back to the Prime Minister on where he's gotten to.
But he's got to act with authority, surely.
Of course.
There must be some guidance as to what authority he has in the pursuit of the resolution to the crisis we're confronted with.
Senator, in terms of authority, Minister Wyatt's been very clearly asked by the Prime Minister to resolve the issue in a timely, reasonable and fair manner, and to resolve it ensuring that Mr. Thomas's rights are respected, that the commercial interests of other parties are respected, and that in the broader public interest in the flying and display in a dignified and respectful manner is respected. How all of those pieces will come together is a matter at the moment for those negotiations between Minister Wyatt and the other parties.
So do you see any legal impediments in the current legal landscape that may need changing to facilitate an amicable outcome here?
Senator, I'm afraid I'm simply not close enough to those negotiations to understand what the possible outcomes might be and whether they would involve or require legal or legislative amendment.
Is anyone else able to help?
Senator, I think this is Emma Shadbolt on the speaking. I think some of the other witnesses have gone through some of the possible legal impediments, and I think they've particularly in relation to copyright. And as we've outlined today, because Mr. Thomas does have those exclusive rights, that's an issue which the government has to consider, and I understand the NIA are considering as part of their negotiation. So that is an issue, and you would probably call it a legal impediment. The question about whether it's appropriate that the Copyright Act is amended to deal with that, or that another option, as is being explored with Mr. Thomas, should occur. We don't have an opinion on that.
Thank you, Madam Chair.
Thank you, Senator Dodson. I'm just seeing if Senator Stoker is still on the line.
I am,
Okay.
Senator McCarthy.
You have the call, Senator Stoker.
Look, I think I'll just get my video started. Is that video coming through now? Yes, great. Thank you. Please excuse the background noise. There's some construction going on nearby. The matter, I think, that is highlighted by much of the discussion that we've had today is just how little people really know about the importance of the Aboriginal flag, the Torres Strait Islander flag, and importantly, the Australian national flag and their relationship to one another. The very fact that everybody in this committee and probably in the wider parliament knows the name of Harold Thomas and is prepared to engage with the tension between his rights and the rights of the broader Indigenous community, but wouldn't even know the name of Ivor Evans, one of the people who won the design competition for the Australian national flag and who was just 14 years old, I think speaks volumes. So I'll implore those at the Department of Prime Minister and Cabinet to step up those education duties and otherwise hand over the call.
Thank you, Senator Stoker. Mr. Reid, can I just ask a couple of questions here? Just following on from my questions previously, are there any other symbols of national significance, not necessarily limited to flags, where the rights of the copyright holder have been altered in some way over time due to the item's recognition as a symbol of national significance?
Senator, I think I would have to take that on notice. I just don't have that information in front of me.
Sure, yeah. Just certainly take that as a question on notice, and as you know, it's September 18 for the response. I'd like to just go to your submission in relation to the flags. I did put this question to a witness on Monday in terms of, again, senators and members and politicians in state and territory receiving flags. Do you, and I'd like to put it to you as well, do you know the number of flags that do go out to senators and members and state and territory politicians?
Across all of the flags?
Sorry, Aboriginal flags.
Aboriginal flags. No, I don't have that information. If it was
I mean, is it something that goes through, I mean, is that something you would be aware of in terms of the Flags Act?
Senator, I think the Department of Finance would be aware of those issues. They manage the office entitlements matters around representational issues and things like providing to members and senators flags and those sorts of things. My understanding is they would have a sense or a record of the sorts of things being provided under those programs to members and senators.
So do you have a data base in terms of the Australian flag, the Aboriginal flag and the Torres Strait Islander flag being distributed?
No, Senator. We have in Prime Minister and Cabinet records of distribution of things like Australian national flag information and Australian national flag materials that are being sent out through the Assistant Minister's office in promotion of Flag Day and things like that. That's what we maintain. The Department of Finance may maintain other records about all of the items that are provided to ministers and members and senators' offices through those representational programs.
Mm-hmm. Mr. Reid, this I've got a question around a document that was tabled on Monday, so it may be you or it may be you, Mrs. Shadbolt, just to assist the committee to understand a little bit more about the document. This document was tabled as by the NIAA around the Aboriginal and Torres Strait Islander Commission's contract with Mr. Thomas. And I'm just wanting to understand a little bit about this document, and I'm happy to see if it can be provided to you. But the document it's about 4 pages and looks at the copyright relationship between ATSIC. It's on the inquiry webpage if any of your staff are there. So the agreement was made on the 17th day of December 2001. And so I've just got the document here, and I'm sure you've seen plenty of documents like it, Ms. Shadbolt. Are you able to walk us through this kind of document in terms of the relationship with the Commonwealth and a copyright holder more broadly?
Broadly, I think it'd be difficult because it's a legal document, and it would have been something that would have been done at the time by ATSIC's legal advisors, and the question about what impact it has now would need to be based on considerations of those other exclusive licences. So I think I am probably not in a position, and I probably decline to be in a position to go through that from a legal perspective, or even from a general perspective, and also that we have not been asked to provide advice to government or to the NIAA about the effect of that document. It's something that we've left with the NIAA to deal with, given it was an issue from ASIC. So,
but would you have obviously. I'm trying to understand how this process works or would have worked in that instance. And when there is a document that has been signed between a copyright holder and the Commonwealth,
yes,
even though ATSIC no longer exists, what would have happened to
so there is different principles now between earlier. The Commonwealth has the Australian government IP rules, which provide guidance on how Australian government agencies should manage their intellectual property and how different types of IP should be used. And we can provide you a copy of the current guidelines. That provides advice about parts of government contracts and agreements that are about IP and how they should be negotiated, publication and licensing of government information, and around government use of copyright material. So there are those principles in place now that would help guide consideration about how to currently negotiate for use of copyright material and IP more generally. And that's something that would be done on a daily basis in terms of procurement contracts and those types of things, and on a case-by-case basis by the agency themselves dealing with it. We provide that general advice from the department, but otherwise we recommend that agencies seek their own legal advice in terms of the contracts they're undertaking and the issues around IP.
But in this instance, with the demise of ATSIC, what would happen to a contract like this? Does it just become collateral damage as a part of the demise of something?
That would probably
have been maintained?
Sorry, Senator. That would probably go to the principles around contract law, and so hence why I say it's probably an issue more that there would need to be legal advice considering around what happens when a party to a contract is either no longer in existence or may have changed existence, and that's an issue there where I think there'd need to be advice on that basis and consideration on that basis rather than from a copyright basis.
So, in terms of the Commonwealth, though,
yep,
and I understand about going to the contract law and the legal aspects of it, but in terms of the Commonwealth's responsibility, and in this case to Mr. Thomas. Who would have had to ensure that responsibility continued, even though the actual organisation of ATSIC didn't?
My understanding, Senator, is that generally in those cases it will pass on to either the new agency or the new department that's responsible for those issues to consider whether that agreement should continue or whether to undertake further engagement.
Okay, so there's a large gap between the time when ATSIC was expired to the NIAA being established in the last 12 months. So who would have been responsible in that time frame?
I unfortunately am not aware of who would have been responsible for it in that time frame.
Mr Reid, are you able to answer that?
Senator, I'm simply not aware of the arrangements around the end of ATSIC. It would turn, as Ms Shadbolt has said, on the successor organisations and whether or not different organisations picked up different rights and obligations. Simply not across the legal frameworks there, Senator.
I'm just trying to understand. I'm sure there are lots of other contracts that needed to be looked at as well when ATSIC went down. Are you able to take further that on notice? Because we do want to understand, clearly there is a major gap there. There was obviously a contract between the Commonwealth and Mr Thomas, and then it just disappeared. So if you're able to find out what's happened in that time frame between the demise of ATSIC to obviously when this document was tabled to us by the NIAA, that would be really helpful.
Certainly, Senator.
Thank you, Mr Reid. I note that Senator Stoker has further questions, so I'll just go back to you, Senator Stoker.
Thank you, Madam Chair, for being so accommodating. My questions go to probably the people from the Department of Communications, but I'll let the witnesses decide who the right person is to answer. But in this committee, we're trying to resolve this tension between the community connection that's deeply held to the Aboriginal flag and the private property rights of Mr Thomas in the intellectual property associated with his art. In many ways, that's a sign of a highly successful artwork, that it's become such an enduring symbol. But what would the impact be of failing to protect or indeed to take the intellectual property of an artist like Mr Thomas in terms of its bigger picture impact?
Sorry, Senator, are you asking what the impact is if the copyright is not enforced over time, or...?
Look, yes, if the Commonwealth were to simply take his intellectual property, either without compensation by legislation or without his consent but subject to compensation. If we were to be taking the intellectual property or not enforcing the intellectual property rights of artists, what impact does that have on the broader community of Indigenous people and in particular Indigenous artists?
Thanks, Senator. I think a number of witnesses attested to this earlier on Monday about the concerns that would be had if the government was to acquire the rights directly without any compensation, given that it is under copyright, it is the economic rights and the issues around Indigenous artists more generally. So I refer to those comments. I think those comments articulated the issues there and the concerns that would be in place if the Commonwealth did determine to just acquire it. And given that Mr Thomas has successfully, through his federal court action, outlined and been seen to see as the copyright owner, and in that case the Commonwealth did have to pay past remuneration to him, I think that is a clear indication of the fact that that copyright is being clearly held by Mr Thomas, and that there would be an issue in terms of if the Commonwealth did nothing but try to use that without permission, there would be obviously the ability for Mr Thomas to take further action.
And do you endorse those comments made yesterday? You certainly referred to them, but do you agree with them?
Given my position as a policy officer, I can't endorse those comments, but I just refer to them as indicating the general sentiment around the issues in terms of acquisition of copyright.
Given your policy role, though, you are able to speak to what are the obvious consequences of a policy decision. And if a policy decision is taken to take away somebody's intellectual property without their consent, then you are able to speak to the policy consequences of that, and that's what I'm asking you.
Yep. So I think, as I've articulated, the likely policy consequences on the facts as we see them at the moment would that Mr Thomas would, without appropriate negotiation or consultation, would have the ability to take action against the Commonwealth. But again, I have not considered this in significant detail, or I've not been asked to provide advice about these options. This is something that the NIAA have been considering in their negotiations.
Does the failure to protect the private property rights of artists generate a disincentive to cultural expression through art?
Senator, I can't answer that directly. I think the issue is that we have a Copyright Act to provide the exclusive and moral rights to artists in their work to ensure that they can get both economic returns for that and also recognition for their artistic works and be able to deal with that at a legal on a legal basis. So from that perspective, the policy for copyright and IP generally is to give those rights and ensure that people who appropriately acquire those rights can utilise them.
Let me frame it this way. Intellectual property rights are important in the scientific research and in the pharmaceutical sphere because unless we protect the private property rights that are produced as a consequence of investment, for instance, in a new medicine, then there will be no incentive for people to invest the enormous sums of money and the time and the expertise that's required to produce that good, that medicine that is good for many members of our community and also an opportunity for its creator to earn a sum of money. Doesn't the same apply in the artistic sphere, where if we take away the ability of artists to earn a living from their art, then we create a disincentive to the creation of great art in this country as a way of promoting and celebrating Indigenous people?
Yes, Senator, I think that's correct. That's the aim of the Act, is to give those incentives both from an economic but also a creative factor to encourage that. Some artists do it for the love of it, but often you need to make sure you have these economic rights to make sure that you can earn the living.
And that's part of the reason why the government's done so much work in relation to dealing with fake art that isn't truly Indigenous, and art that poses as something with a greater cultural significance than it does, essentially a copy. That's right, isn't it?
That's correct.
Thank you very much, Madam Chair. Oh, sorry, I didn't mean to cut you off.
Yes, I'm sorry. I was thinking that you may be referring to the fact that the government announced the Indigenous Visual Arts Strategy consultation, and so obviously the government is taking a keen interest in making sure that there's appropriate frameworks there.
Thank you very much. I appreciate your answers. Thank you, Madam Chair.
Thank you, Senator Stoker. We do have further questions, but given we're also going to have a private meeting, I might take this opportunity to adjourn the hearing for until about 10:45. So we're going to just have a private meeting amongst the committee and call you back at 10:45 if that's okay. Thank you. Are you all on? Senator Dodson? Senator Lyons?
Sorry, Madam Chair, I had my thing on mute.
Okay, thank you. Just checking you're online, Senator Lyons. Thank you. We've got Senator Davey. Just wondering if Senator Stoker is with us. And Senator O'Sullivan. Okay, we're quiet. I'll start. Okay, just reopening our hearing this morning at 14 past 11. Thank you for your patience. That went a little bit longer than we had expected, so I appreciate your patience in this. Senator Dodson, can I go to you with further questions for the agencies?
Thank you, Madam Chair. This is by way of getting some exploration on how to balance, or has there been work done on contemplating the collective interest or collective rights of First Nations peoples in the flag, and the fact that the flag is under Australian law held by an individual through copyright. Has there been any work asked of the agencies to try and grapple with that proposition and come up with any suggestions on how the law might be changed to accommodate this?
Senator, it's John Reid from Prime Minister and Cabinet. Prime Minister and Cabinet has not been involved in any discussions like that. I'm not sure if Department of Communications has been.
No, Emma Shadbolt from Department of Communications. No, we haven't been involved in any discussions around that.
I'm not just restricting it to this particular terms of reference, but have you been involved in that kind of conundrum in the past?
No, Senator. To the extent that it's being looked at, it'd be being led and be looked at by the National Indigenous Australians Agency.
But it seems to me they're looking at a very specific set of problems. They're not looking at the legal framework that could accommodate collective rights more generally as a legal entity as opposed to an individual's property right.
Senator Dodson, it's Emma Shadbolt here. There was the work done through the House of Representatives parliamentary inquiry into inauthentic art, and there was a recommendation in that report, recommendation 8, that there be further work done on scoping, and I'll read it out, to develop standalone legislation protecting Indigenous cultural intellectual property, including traditional knowledge and cultural expressions. And the government agreed to that recommendation, and it was agreed that there would be further scoping work done by the government to consider those issues. This will also fall within the government's announcement around the Indigenous Visual Arts Action Plan, which focuses on a number of issues, including legal protections. So those issues will continue to be considered through that process.
And when was that dated? Sorry,
on the 2nd of September, the Minister for Communications, Cyber Safety and the Arts, as well as the Minister for Indigenous Australians, jointly released a consultation paper on growing the Indigenous arts industry. And that within that there was the government response to, and I will just get you the name of the report on the impact of inauthentic art and craft in the style of First Nations people.
Okay. Thank you very much for that. The question of the manufacturing of goods overseas and not in Australia, particularly the Aboriginal flag, is there any capacity under the Copyright Act that the flag be manufactured in Australia as opposed to manufacturing it overseas?
Emma Shadbolt here. In terms of those rights under the Copyright Act, they're rights for the individual copyright owner or the original creator, and there's no restrictions on how they can undertake those actions in terms of manufacture.
How then do you determine false art or false reproductions?
Emma Shadbolt here. That would be under a different issue, and that was, that's another area of the Department of Communications, our Office of Arts, who have been dealing with that issue through the inquiry into the inauthentic arts. There's quite a bit of background in that in terms of the issues raised there, in relation to how the Australian Competition and Consumer Commission deals with those issues in terms of misleading and deceptive art. And those types of issues. So there's quite a number of, I wouldn't go into them now, but there's quite a number of separate issues in terms of those concerns.
Chair, it's Michael Schwager here. If I might just
Mr.
come in
Schwager?
and contribute. Michael Schwager, Director General of IP Australia, and I too would just like to acknowledge the 9am people as the traditional custodians of the land on which we're meeting, and pay my respects to elders past and present, and extend my respect to all Aboriginal and Torres Strait Islander peoples here today. Just by way of introduction, IP Australia is the agency responsible for the administration of registrable IP rights, so specifically trademarks, designs, patents and plant breeders' rights. We don't deal with copyright, but we do have at the moment a policy contribution and a work program aimed at ensuring the IP system tries to support in an appropriate and respectful way both traditional and contemporary representations of Indigenous knowledge and culture. And just to follow on from Senator Dodson's question and the information from my colleague, examples in that work program that go to this issue include, for example, that we are exploring the use of blockchain-like technologies through an Indigenous IP trust badge, which might allow for consumers to click on a trust badge as part of, say, electronic commerce and have a link back to some sort of Indigenous authentication process. And one of the examples of that, and it's in the work program and it's part of the government's response to that inquiry into counterfeit art, is that perhaps the certified trademark system might assist in providing some sort of protection or protection against counterfeiting by having a certified trademark for authentic Indigenous goods, however that is defined, and that's part of the consultation that would need to take place as part of what is possible. If you then had a certified trademark for authentic Indigenous goods, again, however that's defined, you could then perhaps use this blockchain-like technology to provide a trust badge that again allows consumers to click on a trust badge. It then flows through to our certified trademark register and then pings back with an authenticity tick that gives consumers comfort that they're buying the real thing. So they're the sorts of mechanisms that we are looking at as part of our work in administering registrable IP rights. I have to emphasise that that does not include copyright.
Senator Dodson?
Chair, I had that mute thing on again. Problem with waking up so early. Has anyone on the panel had any dealings with the federal court matter that imposed a fine of $2.3 million on Werribee Arts was selling over 18,000 fake imposed items from Indonesia and basically lying about it to the Australian community. Was anyone involved in that?
No, Senator, I'm just conferring with Ms Shadbolt, and neither her department nor Prime Minister and Cabinet were involved in that matter.
So who would track the changes of a company that was subject to those sorts of rulings and then morphing into a new entity but sustaining the same level of operations?
Senator, I understand that matter was run by the ACCC, so it would likely be a matter for the Department of Treasury.
Okay, thank you very much. No further questions, Madam Chair.
Senator Davey.
Thank you. I just want to clarify, and maybe the Copyright Agency can assist with this. The difference between fake art, which I know that we've got a consultation paper out about Indigenous arts and identifying fake art, but there's a difference between fake art or art produced potentially overseas but under licence from the original artist. Is that the case?
Thank you, Senator. I'm not sure to what extent I can assist, but my understanding is that fake art has been produced in a style of Indigenous art, but has actually been created by Indigenous artists or approved by them. I guess the difference with the articles manufactured overseas is that it's possible that that was authorised by an Indigenous artist to manufacture something overseas and export it back into Australia.
Would you, and this may not be within your remit, but would you have a line of sight as a licence fee collecting agency as to how many such arrangements may be occurring where the artist, you've got an Indigenous artist who is being paid a licence fee from an overseas manufacturer?
No, we don't. We manage our own licence based on the agency from our members, but we're not monitoring licensing done outside the licenses that we ourselves look after.
Thank you. And this is more of an open question, but whose responsibility is it when seeking to reproduce an artwork? Whose responsibility is it to determine the ownership or indeed the existence of a copyright and therefore the ownership or the original author of an image?
That's probably a slightly difficult question. In infringement, and again, this is not my area of expertise, but my understanding is in copyright infringement proceedings, if the purported infringer contests the copyright ownership of the person who is bringing proceedings, then that's a matter for the court to decide whether or not that person in fact owns the copyright and is entitled to bring those proceedings.
So if I was doing a search online for images and I found an image that I liked, that I then copied and pasted and then put on my brochure and started distributing it, it would be up to the court to decide whether I breach copyright rather than me actually having to determine prior to using that image whether there was a copyright in existence.
I'm very sorry because I misunderstood your initial question. No, if you are a person who is using an image that is has been created by somebody else, then you would normally need the permission of that person to reproduce that image, and you would need to identify who the copyright holder is and ask for permission to do that. So the onus is on the user of the image to find the copyright holder, request permission, and negotiate any terms that that the copyright holder might want to negotiate. Sorry, I misunderstood the earlier question.
Thank you. So on the back of that, my question now is to Prime Minister and Cabinet. Prior to declaring the flag a national flag in 95, what steps were taken by the government of the day and indeed the people they were consulting with to determine the origin of the flag prior to actually making that determination?
Thank you, Senator. I'm not aware of the process that was followed after the Council for Aboriginal Reconciliation made that recommendation to the government. I will take that on notice.
And it would be interesting if there were any available minutes from the Council for Reconciliation to determine what steps they indeed took to identify the original authorship of the flag, because that would explain a lot as to how we got here today. Given that Mr. Thomas felt it necessary to take the matter to court post the declaration. So if you could take that on notice, that would be appreciated.
Yes, Senator.
Thank you. That's all from me at the moment, Chair.
Okay, Senator Davey, I understand there may not be any further questions from Senator Stoker and Senator O'Sullivan. Just checking with you, Senator Dodson, if you have further questions for the witnesses.
Madam Chair, I'm fine.
Okay, thank you, Senator Dodson. Senator Davey, was there anything else that you would like to ask before I conclude?
No, I appreciate how much time, and I thank all the witnesses that have appeared.
Thank you, Senator Davey. So on that note, can I thank you all for your time this morning and again for your patience. But we have appreciated the opportunity to ask questions around the Aboriginal flag and other flags. And of course, you do have questions on notice, Mr. Reid, that we'd certainly like to see responded to. And if anyone else was also asked questions on notice, September 18th is when they're expected in. So thank you again for your time this morning. So, on that note, we shall conclude the hearing and we shall adjourn until next week. Could I just do some formalities before we do? There were no documents tabled throughout this hearing, so it certainly concludes today's proceedings. The committee has agreed that answers to questions taken on notice at today's hearing should be returned by Friday 18th of September. I certainly thank all the witnesses for your evidence today. Thank also to Hansard Broadcasting and the Secretariat, and to the senators. I declare the hearing adjourned.